Georgia lawyers Bob and Irreverent D talk law. Listen up for stories about how things really happen in our legal system. Who are these guys? Dwayne Singleton, Irreverent D, is a criminal defense attorney in the state of Georgia. Benjamin O. Benson, a.k.a. Bob, is a personal injury attorney in Atlanta. Today, the boys welcome back show favorite, Adam Taylor. Now, sit back and take a listen as Bob and Irreverent D talk law.
Welcome to the Bob and Irreverent D Talk Law podcast. I'm Bob. That stands for Benjamin O. Benson of the Bob Law Firm. We're a personal injury practice in Atlanta, Georgia. I am joined, as always, by Irreverent D, Dwayne Singleton of the Singleton Trial Lawyers Group in Griffin, Georgia.
There we go.
And today we're joined again by a friend of the show, Adam Taylor.
Thank you for having me. I appreciate it.
Glad to have
Always
you.
a pleasure to be here, Ben.
It's wonderful. Tell our audience for a minute about your practice.
So my practice, I work here in Atlanta. And I do third-party liability practice. Most people commonly refer to it as personal injury, just like you and Dwayne. And I do estate planning under Your Legacy Lawyer. And
Your Legacy Lawyer.
Your Legacy Lawyer. You can Google it, or yourlegacy.lawyer is the website. And
.lawyer. So you picked up that suffix instead of .com.
that's right.
.net or .info. It's .lawyer.
It's .lawyer because I'm a lawyer. I'm not a com. I don't need a
That's right.
.com. Yeah,
We're not-
I
we're
went
not
with .lawyer.
not
Your,
.inc.
Your Legacy.lawyer. I'm a
That's
lawyer.
right.
That's what I'm.
Very good.
Yeah, sure.
Well, today we're talking about apportionment, which
Oh, that's a fun topic. Yeah.
can we talk about this for a second? The reality is that for us lawyers, it's like super interesting.
Right.
Yeah.
For most everybody else, it's
They're
like,
like, what are you
what?
talking
I
about?"
don't even understand.
I call it the sue everybody law.
Right. Why do you call it that?
Because apportionment means that anybody that you don't sue, a defendant can ask a judge or jury to apportion fault to that entity. So if you get hurt and you think that entity A, B, and C played a role in your injury, but there's entities, D, E, and F that are kind of on the fringes that you don't think they really have any culpability, you don't sue them. You just sue the main people you think that hurt you. But now, since they've passed apportionment, you look at a case and you think, if I sue A, B, and C, the defense is going to file a notice of apportionment against D, E, and F. So I ought to just sue everybody.
I just sue everybody.
I just sue everybody, just
Well,
to
they
make
used
sure.
to blame
that-
it on us. They're like, oh, it's like spaghetti, right? You throw it up on the wall and
Yeah.
see what sticks. But now you have to do
You
it.
have to do it. I mean, tort reform has given us no choice. And I really feel sorry for some of the businesses that get caught up in this, and that.
Yeah, because
So
when I'm
tort
sitting down,
reform-
when I'm sitting down and thinking, all right, now, Ben, who should I sue? There are 4 potential people that are responsible. But in some circumstances, in previous circumstances, I might say, well, the person we really think is responsible is Jim, right? We sue Jim. But in today's world, what I do is I say, screw it, sue them all. We'll sort it out.
Yeah.
So tort reform has actually caused more people to get sued.
Way more people.
Right.
Yeah. Significantly higher numbers. Where before you would just sue 1 or 2 people who were at fault, now you've got to sue probably 10 people, the 2 people who are at fault, and then the 8 people who you think those 2 people will just try to point the finger at. You got to bring them all into the table because of the tort reform. Yeah.
So the news item today has to do with apportionment, and we're going to talk about, I'm going to spend a couple minutes just talking about what happened.
Let's get into the news.
The news item is that in Bibb County, there is a...
That's in Macon.
That's Macon is in Bibb County. That's right. South of here for a couple hours. This plaintiff filed a lawsuit against a pharmacist and got a $40 million verdict. Here are the facts. The plaintiff might have had some psychological issues. She was admitted to a psychiatric institution. And as a result, she was prescribed this medication called Lamictal. And anybody who is, I did not know this, I had to look it up. But apparently, anybody who has anything to do with understanding bipolar disorder or seizures knows you cannot just administer the highest dose of Lamictal right off.
You got to
because
wade into it.
Sure.
You got to, well, the titrate is the word they use. You have to
Build a tolerance.
You have to build into it, right? And if you do give them the full amount right away, bad things can happen, and that's what happened. Bad things happened to this lady. She broke out all kinds of rashes. Her skin started desiccating. Her organs started messing up. I don't want to get into all the gory details. But she had to have what the plaintiff's attorney described as $3.6 million in medical bills.
Well, I was going to say a $40 million verdict, something serious happened.
Something really bad happened.
Yeah.
Right?
12 people agreed that $40 million was adequate.
That's something really bad. I don't know what happened, but it sounds like it was really bad.
Yeah.
Right. So the plaintiffs, so here's the catch.
So the allegation is that the pharmacist should have caught this?
Exactly.
Okay.
Right. Now, now think about this for a second. Dwayne, who else could you have blamed for this?
Well, the doctor,
Right.
the hospital, the nurses group, if there is one, right?
All kinds of people.
there's
Should have caught that.
Right.
Right. So, in fact, that's what happened in the trial is the jury found that the damages were $40 million, but only found the pharmacist 2% at fault.
Sure.
And the other defendants, the other people who weren't even defendants in the case, were 98% at fault.
And that's what juries do.
Right.
I mean, juries do their job.
That's what they're supposed to do, is to say, well, okay,
And this is one of those little things in the law. You can't really explain how that's all going to play out, right?
you can explain how it could play out,
Right.
but you don't know how it's going to play out.
Right.
And so if the hospital and the doctors and the nurses group and the other people who had fault apportioned to them, if they're not parties to the lawsuit, they're not liable for paying any part of that judgment, correct?
Right. Now, yeah, that's right. But what does party to the lawsuit mean?
If their name is on, if they have a defense lawyer at the table defending their position, if they're an active participant.
So they're going to be named, served, have an opportunity to answer.
I'm thinking that before this lawsuit was filed, the institution, was it a hospital?
Or the hospital. It's a state-run hospital.
Yeah, state-run hospital, the doctors, the nurses group. I'm thinking they probably just said, look, we made a mistake. We want to own up to it, and they settled. So I'm thinking they probably settled before this lawsuit was filed. And even if a party settles before a lawsuit is filed, a jury can still apportion fault to them. So, if it's a state-run hospital and their liability is capped at $1 million, and the hospital says, sorry, we made a mistake, we feel bad about it, here's our $1 million limits, they can still be included on the verdict front.
Now explain why there's only $1 million limit with the state hospital.
Well, it's not like a hard and fast rule about it. The State Tort Claims Act governs what the state is willing to waive its sovereign immunity up to certain levels
We've seen
in
some
certain
verdicts recently
situations.
that have been over that, right?
That's correct. They waive sovereign immunity to a certain amount in certain situations for certain different entities, and it kind of fluctuates a little bit between whether it's hospitals or whether or not it's the Department of Corrections or the Department of Transportation, or but most of that is governed by the State Tort Claims Act.
All right. So nearly all of your assumptions were correct.
Okay.
Here's what survey says.
Oh, survey says.
Survey says that under the Georgia Tort Claims Act, that you were right. The state agency had $1 million damages cap.
Okay.
And the nurse couldn't be sued because she was a state employee.
Okay.
And
she has qualified immunity.
Qualified immunity, and
Which I hate.
we talked about this. We talk about it almost every
That's
week.
a different episode.
That's a
You guys
different,
talk
whole
about
other
it?
episode,
Okay,
yeah.
gotcha.
And the supervising doctor was an independent contractor,
Oh, okay.
filed bankruptcy. Judgment proof.
Yeah.
Yep.
That's a
Poopy.
jerk out. Yeah. Or cop out. That's a jerk out. I'm gonna cop out. Yeah.
That's a what? Anyway, so it's the moral of the story, though, is okay, you get a $40 million verdict, but you still got 2% against the pharmacist. That's what.
800?
800,000.
800,000.
Right. So you got.
I'm good at math, man.
I'm not a math person, so I'm glad you are. So, yes, huge, major problem.
Yeah.
Right. But some recovery because presumably she settled with the state for $1 million and got an $800,000 verdict that could be
But clearly the jury didn't understand all that because they wanted to have $40 million.
Yeah.
And she got $1,800,000.
And the lawyer, I don't know, does it say who tried? I don't want to put names out on
The guy's
show.
name is Spatials.
Spatials? I don't know. But that's like in closing arguments, that needs to be clearly explained to the jury about what apportionment is and
Beckhouse. I don't know the guy. But in the article, it quotes him pretty extensively saying, hey, look, as a trial attorney, we have to make decisions about like what we think could happen, and there's just limits to what we can do.
Yeah, so it sounds like this might have been a cleanup trial.
Right.
I've had a few cleanup trials. I believe we've tried some cleanup trials ourselves.
We have.
Yeah.
We have.
Where you make a recovery from the main tortfeasor and they pay their limits, and you're like, somebody else is partially at fault. Why don't you pay your portion? They say no. We want to go trial, and you go try it. And they apportion the fault, the way that they're supposed to. I've probably had half a dozen different cleanup trials where the main tortfeasor pays out their limits. They accept responsibility. They pay the injured party, and the other people are like, well, that person is mostly at fault, and we're only part at fault, so we don't want to pay anything.
Right. And tortfeasor is
the at fault, the person who's screwed up.
Right.
The person who screwed up. Yeah.
Yeah. So if you're injured because of the conduct of another person, and that person is wrong, they're responsible to you for your damages.
Right.
That's the tortfeasor thing.
Correct. Yes.
Okay,
Yeah.
I got it.
All right.
Well, that's as much time as we have.
Okay. Sounds good, guys. I
Thanks
appreciate
for
you guys
joining us
having me on the
again.
show again.
What a great episode. Great time again.
It's always a pleasure.
Make sure that you email us at bobandidtalklaw@gmail.com. Make sure that you subscribe. You do not want to miss anything, especially any further follow-up episodes about apportionment or comparative fault, because like it could mean the difference between an $800,000 verdict and a $40 million verdict. Thanks for joining us.
Thanks for listening. Tune in next time when Bob and Irreverent D talk law.